Hello and welcome to the course on Indian polity. Finally, we have come to the last lecture on part third of the Indian Constitution, that is the fundamental right. We have been sufficiently having discussion on the part third of the Indian Constitution, and I believe that you must have gained so much on part third of the Indian Constitution. In this lecture, we are going to discuss the remaining articles which are simpler and which are straightforward, that is Article 33, 34, and 35. And these are not considered the part of the fundamental rights, but are mentioned under part third of the Indian Constitution, that is the part fundamental rights. But when we have seen that the broader categories of the qualifications of the fundamental right, the last one was Article 32, that is the right to constitutional remedies. So, what are there in Article 33, 34, and 35 that we will be seeing in a moment? But before that, let us just go back to the previous lecture and just revise what we have done in the previous lecture. In the previous lecture, we have discussed Article 32, that is the heart and soul of the Constitution, as said by Dr. B.R. Ambedkar. And we have sufficiently discussed the different types of writs that can be issued by the Supreme Court or the High Court. So, we have also seen that if I am a aggrieved person, I have two options. I can either go to the Supreme Court or to the High Court. I have the constitutional remedies under Article 32 as well as under Article 226. Under 32, I can approach Supreme Court, and under Article 226, I can approach the High Court. Which court should I choose will depend upon my convenience, how much I have to travel. I will prefer to go according to my suitability. I may reach to my nearby High Court or I can go to the Supreme Court. Both the remedies I have, both the options I have. But there is a difference in the writ jurisdictions of the Supreme Court and High Court, and one of the difference was that the Supreme Court has no discretionary power, whereas the High Court has discretionary power. When I say this, do not get confused. Discretionary power means in the acceptance of with respect to the writ petition. The High Court either can accept or reject the writ petition filed by you because Article 226 does not form the part of the fundamental rights or part third of the Indian Constitution. Whereas when you approach to the Supreme Court filing a writ petition, the Supreme Court has no choice but to accept the writ or issue the writ because it cannot refuse issuing of the writ because that remedy is provided to you under Article 32, which forms the part third of the Indian Constitution or itself is the core of the fundamental right. So I hope Article 32 is sufficiently clear to you. Let us now move forward and discuss the remaining portion of the part third of the Indian Constitution and wrap this part and then start a new chapter, a new part of the Indian Constitution, that is directive principle of the state policy. Moving forward, let us discuss Article 33. So, Article 33 empowers Parliament to restrict or modify the fundamental rights of members of the armed force, parliamentary forces, police, or intelligence agencies, because you see the nature of the service that these are related to basically demands the anytime and every time service. And the nature is so serious that obviously the fundamental rights to some extent should be modified when it comes to national security, which is handled by these agencies, that is the armed force, paramilitary force, police forces, and the intelligence agencies. These restrictions are necessary to maintain the discipline, security, and efficiency. For example, these forces cannot join political parties or unions, although you have the right to assemble peacefully, you have to right to form a union and association. But when it comes to the security forces, this fundamental right is verified, modified and restricted. So only the parliament and not the state government. That means if there is some restrictions to be imposed with respect to the fundamental right for the people working in these categories, who has the authority? The parliament or not the state government to pass such law. Thus, Article 33 is inserted in the part third of the Indian Constitution, in the fundamental rights of the Indian Constitution, to balance the national security as well as the individual right. That is, neither the individual rights get too much prohibited or too much restricted, nor the national security should be challenged or risked. So, Article 33, when we say it powers describes the power of the parliament. See, and remember, it is power of the parliament to modify the fundamental rights and with respect to armed forces, police, and intelligence agencies. That means Article 33 gives Parliament the power to restrict or modify fundamental rights of certain groups whose duties require discipline, secrecy, and national security. In the example, we have the armed forces in which we have the Army, Navy, Air Force, paramilitary forces, that is CRPF, BSF, CISF, ITBP. Then we have the police forces, intelligence agency for IB and RAW. People working in this, some sort of fundamental rights will be modified, and but that has to be done by the law. And who has the authority to pass the law? The parliament. Then personnel employed in the maintaining of the public order. Even telecommunication people come under this. So only parliament can impose these restrictions. So state legislature cannot modify fundamental rights of these forces. Restriction must be law made, not executive order. No, cannot pass an order and restrict this. You have to make a law, and law will be made only by the parliament, not the state. The state legislature cannot make law and modify the fundamental right. So this was Article 33. I hope this is clear to you. Let us move to Article 34. And in Article 34, let us discuss the restrictions on the fundamental rights during the martial law. So these are basically Article 33, 34, and 35 talks about, yes, we have given you the fundamental right from Article 14 to Article number 32. But now there is certain modification in these fundamental rights when it comes to certain specific categories of the people. Article 1213 describes the prepare the prerequisite to understand the coming article. It defines the states, the law. Then Article 14 to 32 defines all the fundamental rights, and then Article 33, 34, and 35 describes that yes, there is a fundamental right. I understand, but in order to balance the right and the national security, there should be some modification and the right, and that will be done by whom will be described under Article 33, 34, and 35. So, under Article 34, it empowers the Parliament to restrict the fundamental rights during the martial law. What is the martial law? We will understand it in a moment. But Article 34 allows the Parliament to indemnify military and civil authorities for action taken in good faith during such situations. For example, say suppose in martial law, say, first of all, at this point, just understand that martial law is the law that is imposed when there is no other option left. So why I'm telling this? Because in the history of the Indian government, till now, martial law has not been imposed. Okay, till now the martial law has not been imposed. So if it is imposed, it will be the last remedy available for the government. It will be the last what we say as the option. So the martial law will be imposed. Now, when the martial law is imposed, it means the law and order is not the law and order is violated to the very bad extent, to the extreme, you can say, to the extreme, and then martial law is imposed. Now, when the martial law is enforced, the authority, mainly the armed forces, are given immunity. That if you do something, you are given immunity. If you do something, if you commit a crime, that is, if you restrict someone's freedom, if you do some other things, you will not be treated as guilty, or you will not be uh, means that means you cannot be prosecuted later for the action you have taken during the martial law was enforced. And that is why it is made so harsh. That is, if there is no option to restore back law and order, it has gone so worse, so extreme, that the restoration of law and order by normal laws is not possible. Then the martial law is imposed, and the imposition of martial law itself inflict fear on the violators of the fundament of the law and order, that if the martial law is enforced, the police or the armed forces who is now responsible for maintaining law and order can go to any extent, and for that course of action they cannot be prosecuted under any law, because they are protected under the martial law. So martial law is imposed only during extreme breakdown, first condition. When there is an extreme breakdown of law and order, when the army temporarily then then the armed forces, that is the army, temporarily takes over the civil administration just to restore back the law and order. So Article 34 ensures that the legal protection and clarity during such extraordinary circumstances. So this is the main purpose. So Article 34 says that yes, there should be the restrictions of the fundamental rights of the citizen whenever the martial law is enforced. And why the martial law is enforced? Yes, there is an extreme breakdown of law and order. To restore that, the army personals, the armed forces are given the responsibility. Now, in order to execute the responsibility, if they commit something, they will not be prosecuted later. That is what is martial law is. So it is a temporary taken over of the civil administration by the military personnel. That is the martial law. Temporary takeover of the civil administration by military, imposed only in the case of extreme emergency such as warlike situations, internal rebellion, total breakdown of law and order. India has never officially declared martial law post independence, but the constitution provides for it. There is a provision in the constitution, you can do that. But till now, so the situation has not gone so worse that the martial law is required. So the parliament can restrict fundamental rights. Just like Article 33 for armed forces, Article 34 allows temporary restrictions on the rights of ordinary citizen in the martial law area. So wherever the martial law is imposed, there is a restrictions on the fundamental rights of this ordinary citizen. Article 33 restrict the fundamental rights of the people related to maintenance of law and order. That is, they are working in the paramilitary force, they are working in the armed forces, police forces, IBs, etc. 34 restrictions on the fundamental rights of the ordinary citizen wherever there is an imposition of the martial law. So also we have discussed that there is a restrictions on the fundamental rights during the case of emergency. So we will discuss what are the differences between the martial law and emergency. But remember, during emergency, your fundamental rights is also suspended. It is not enforced. It cannot be enforced. And not all the fundamental rights are suspended. Few fundamental rights are still exercised and not suspended during emergency. That we have already seen. So the parliaments can indemnify officials, that is in the army or official, if the army or official uses force or take strict action during martial law in good faith, the parliament can pass a law saying they cannot be prosecuted later. This is also called as indemnity legislation. What is called the indemnity legislation? The legislation which is passed to protect the officials who take strict action during martial law in good faith so that they cannot be prosecuted later is called as the indemnity legislation. So let us understand what is the difference between the martial law and emergency. In martial law, army takes over the control of civilian administration. In emergency, civilian government continues. The government is not suspended but with special power. Be applicable only in the specific area. It can be nationwide or statewide emergency. Emergency can be for the entire country or of a particular state, but the martial law can be for a specific area. The area where the law and order is breakdown, where there is a breakdown of law and order. In that particular area only martial law will be applicable. The army will take control of that particular area. It is authorized by Article 34 that we are seeing. Emergency under Article 352 and 356. One is called as the state emergency, another is called the national emergency. State emergency is also known as the imposition of the president rule. So extreme breakdown of law and order will result for inviting for the application of the martial law, but national emergency can only be declared on three grounds, that is the war, external aggressions, and internal disturbance. Why Article 34 was included? Because army actions during the rebellion or extreme situations do not become legally questionable. To protect them, the main objective remains what? The main objective remains restoration of law and order. So for this, you may have to take some strict action, which may be against the part third of the Indian Constitution. And for that, indemnity legislation is to be passed by the parliament. So the officer are not prosecuted later for act necessary during the crisis. Law provides clarity and controls over the martial law implementation. So this is what Article 34. So difference between Article 33 and 34 is that 33 put restrictions on the fundamental rights of the special categories of the people. 34 puts the restrictions on the fundamental rights of the ordinary citizen under special circumstances, that is the martial law. What does Article 35 says that? It says that the parliament has the power to make laws for certain fundamental rights. That is, certain fundamental rights are automatically enforced. That is right to freedom to movement, right of freedom of speech and expression. We do not require any law. So there is a freedom of speech and expression, the freedom of trade and business and all that. But for some fundamental rights, there need to be some law, such as the prohibition of, that is the protection of right against exploitation, that is prohibition of human trafficking, prohibition of child labor, prohibition of untouchability. For all that fundamental right to get enforced, you have to make law. And who is authorized to make law for anything related to part third? That is the parliament. So parliament has exclusive authority. Exclusive authority means no other body has the authority to make law. The parliament is exclusively responsible to make laws, and laws related to Article 16, Clause 3, that is, Parliament decide what residence requirement are needed for the government job. State cannot, and their own residency rules unless Parliament authorizes. So, while discussing Article 16, I said that Article 16, Clause 1 and 16, Clause 2 provides the fundamental right, that is equal opportunity into public employment, and no discrimination on the basis of race, religion, ground, sex, place of birth, and descent. But there, under Article 16, Clause 3, it said that the Parliament can make law whenever residence is a requirement, because there are some specific jobs which is required your local knowledge of the local language, and obviously the people of particular residence will be expert in the local language. So in that case, you can take residence as one of the requirement for apply for providing opportunity under public employment, but also that requirement a law has to be there, and who is authorized to make law? That is the parliament, and that was we have already discussed under Article 16, Clause 3, and that is reiterated under Article 35, that for certain fundamental rights, if there is to be law has to be made, that law will be made only by the parliament and not the state legislature. Even though the state of Telangana wants that there should be a requirement of residence for the particular post within the government of state of Telangana, then also he has to ask the parliament to pass the law to authorize that. Then the law relating to Article 32 that we have discussed just above, that this parliament can make laws to empower the Supreme Court to issue writs, and Parliament can also expand Supreme Court power to for enforcing fundamental rights. That is, whenever there is a law which need to be made under Article 32, who will make law? Parliament. Laws relating to Article 33, that is we have discussed just above, and law relating to Article 34. All this law, who is authorized to make? The Parliament is authorized to make. Just remember one point: whenever there is law which is required to be made for the fundamental right, the only authority or the exclusive authority is given to the parliament. So this was Article 35. Article 33, restrictions on the fundamental rights of citizen of the certain person who is required to maintain the discipline, who is required to serve for the national security. 34, restrictions on ordinary citizen under special circumstances, that is the martial law. And we have understood what is the martial law as well. 35, authorizes the parliament exclusively to make laws, whether you talk about Article 16, Clause 3, whether you talk about Article 32, 33, or 34, the sole responsibility lies on the parliament. The parliament can only make laws enforcing certain fundamental rights or any other matter related to fundamental rights under part third of the Indian Constitution. So when we complete Article 35, we have completed part third of the Indian Constitution, that is the fundamental right. Now, after the completion of all the articles under fundamental right, at this point, it is very fair of me to ask you one question. We have done whole lot of the fundamental rights, so many articles we have done one by one, all the articles, all the relevant cases related to it. Can you, at this point, think of some of the criticism of the fundamental right? Do you think that fundamental right that is guaranteed under Part 3 of the Indian Constitution can be criticized? Is there any point on which the fundamental rights of the India guaranteed under Part 3 of the Indian Constitution should be criticized? Yes, of course. Why not? See, when we go to Article 21, we say that the Article 21 provides the right to life as well as the personal liberty. That is, nobody can deprive me of my life or personal liberty except for the procedure established by the law. This is what is mentioned under Article 21. But who will interpret it? Who will interpret that what is my personal liberty? The Constitution does not make it clear. Who will interpret it? So obviously, it will be interpreted by what? The Supreme Court. So in every right, in every provision of the part third of the Indian Constitution, we have a dependency on the Supreme Court, that the Supreme Court will interpret, and then it will explain what are the meaning of these articles and what are included and what are the derivative of this fundamental right. And Supreme Court has done it, and we have seen it various cases. Whether you talk about the Keshwananda Bharti cases, you talk about the Menka Gandhi Union cases, and the other cases as well. So yes, one of the criticism is very true, that the fundamental rights are too much dependent on the like on the interpretation of the Supreme Court. What are the other? We have only few fundamental rights which are absolute in nature. Other fundamental rights, we have so many restrictions, so much restrictions. We have seen article, there are one article which gives the fundamental rights, and there are several articles which puts restrictions or put an exception to that fundamental right. To name a few, Article 15 clause 1, 15 clause 2 provides the social justice, gives me fundamental rights against discrimination by the state. Then we talk about Article 15 clause 3, 4, 5, 6, exception to that. Article 16 clause 1, 16 clause 2 gives me the equal opportunity under public employment. You go to Article 16 clause 3, 4, 4A, 4B, clause 5, clause 6, exception to that. You go, none of the fundamental rights guaranteed under Article 19, that is right to freedom, is without restriction. There are too many restrictions associated with each of the fundamental right, and yes, that also makes this fundamental right one of the major point for criticism. Also, there are absence of social and economic rights. Let us see one by one what are the different criticism of the fundamental right. We have seen there are too many restrictions. Yes, and absence of social and economic rights are the fundamental right. Rather, these the social and the economic rights are not put under the fundamental rights. They are put under the directive principle of the state policy. That means right to work, right to social security. These are only DPSP, not fundamental rights. And the one of the justifiable reason that was given of the by one of the members of the Constituent Assembly was that at the time of the enforcement of the Constitution, that is 1950, the provision was categorized. That provision that was required, that was the necessity of the citizen of the India, were categorized into two categories: the fundamental right and DPSP. It was not that the provision contained under the fundamental rights were all was were the only provisions that was required for the welfare of the citizen of the country, but also the provision contained under TPSP. But the only difference is that these provisions under fundamental right were made enforceable. These are enforceable by the court of law, and these are not enforceable by the court of law. And the valid reason given behind it, that if the provision of the DPSP were made enforceable by the court of law, it was restricted by certain reasons. The restrictions was put by the financial condition of the country, the geographical extent of the country, the diversity of the country, and the disparity, economic disparity in the country. So, even if the makers of the constitution wanted to include the provisions of the DPSP under the fundamental right, they were limited by so many reasons. And therefore, they decided that the DPSP should be kept separately. They are also important for the welfare of the citizen. They are also sacrosanct in nature, very important, but cannot be made enforceable at that point of time. And we have seen that over the period of time, some DPSP, namely Article 45, that is under right to education, is shifted from DPSP to fundamental right. Similarly, we have seen that Article 39 Clause B, Article 39 Clause C were given priority over fundamental rights. So yes, in due course of time, whatever the provisions mentioned under the DPSP shall be made enforceable if We want India to be a true heaven on earth. And that is not what I am saying. That is the words of the makers of the Constitution. So we will discuss in length the DPSP, but now this is also a sort of criticism that there is an absence of social and economic rights as a fundamental rights. It is put under DPSP. Then it is not available against all the articles. Most of the fundamental rights are enforceable against the state and not against the private individual, except some article, that is article 17 and 23. Then we have the preventive detention allowed under fundamental rights. This is also a criticism. Why you are allowing the preventive detention under the fundamental right? Many scholars says that this contradicts the very idea of right. That at one time you are saying that you have the right to freedom. In the very fundamental rights, you are also allowing the preventive detention under Article 22. So this is also a sort of criticism. Then we have the suspension of fundamental rights, except the right mentioned under Article 21 and Article 19. Sorry, Article 20 and 21. All other fundamental rights are suspended during national emergency. So the Article 20, except Article 20 and 21, all other fundamental rights are suspended during national emergency. So the suspension of the rights during national emergency is also a sort of criticism on the part of fundamental right, because it is said that the personal liberty gets weakened during the crisis time. If there is a crisis, your personal liberty gets weakened. Okay, then there is unequal protection for certain group. That is also a sort of criticism. That is a valid point that we have seen under Article 33. That is the people working under armed forces, police forces, paramilitary forces are treated differently. So why there is inequality when we talk about equality under Article 14? So that is also said that Article 14 and Article 33 contradicts each other, but to somehow this the criticism can be negated by saying that whenever it comes to the national security, the equality does not hold. Whenever it comes to the national security, sometimes you have to sacrifice equality for the sake of security. So the next article, the next criticism is we have complexity and legal technicalities with too much judicial dependencies. And this is what we have discussed in the with as the very first criticism of the fundamental right, that there is too much technical complexities, that is at some time even what leave aside the common man, even the Supreme Court has multiple time changed its decision and interpreted a particular article in different way. When we talk about the procedure established by the law, we have seen that in 1950 Gopalan case, they said that yes, the restriction is not on the legislature; it is only the executive to ensure that the proper procedure established by the law is followed. Then we have seen that further in Menka Gandhi versus Union of India case, it says that no, the procedure established by law does not allow the legislation to pass any law. So the law has to be the law must imbibe the very characteristic of due process of law. So we have seen that there is a technical complexities which in terms provide too much judicial dependencies. So common man cannot interpret and cannot means what to say कि हम खुद ही नहीं बता सकते हैं कि भाई हमारे पास क्या फंडामेंटल राइट्स है. एवरी टाइम वी हैव टू गो टू द सुप्रीम कोर्ट और फिर सुप्रीम कोर्ट बोलता है कि यस ये आपका फंडामेंटल राइट्स के अंदर कवर होता है. So this is also one of the criticism that we have the technical complexity that itself result in too much judicial dependencies. So these are the criticism for the fundamental rights. And with this, we end the part third of the Indian Constitution. And next, we are going to start with the directive principles of the state policy, which is part fourth of the Indian Constitution. And then part 4A, that we talk about the fundamental duties. The reason of me being too much elaborative and explanative with respect to this article, because you should remember from Article 1 to Article 51A all the points, all the articles by heart, because these are like favorite questions, or we can say that multiple times it has come. Articles from part third, part fourth directly ask that which article relate to this, or which article means this, what is article 32, what is article 33, directly comes in the examination of the state PCS and other competitive examination. So I am explaining each article, explaining some story behind it, so you could easily remember all the clauses and sub clauses of all the articles ranging between 1 to 51A. Now from DPSP onward, we'll be increasing our pace, and we will try to cover things more easily with less descriptions. The reason being, what were important? At the very beginning of my lecture, I said that I will not be leaving behind a single point which is important from the examination point of view. Now, when we cover DPSP and the fundamental duties, then we move to part fifth of the Indian Constitution, where we talk about the union, the states, the union territories, and then we move towards the parliament and other thing. Then we will follow a different strategy to what we have been following up till now. So, if there is any complaint, any confusion, any query, feel free to connect with us on our WhatsApp community. Also, we have a Telegram channel, but since we are actively replying to the post in the WhatsApp community, feel free to ask your queries and doubt. And thank you for having patience and listening to me all this time. And if there is any query or a personal comment you want to make, you want to give a personal feedback or suggestion so that we can improve, you are welcome. You have our WhatsApp contact 9973488139. You can reach to us. You can drop a message. We are available on the message, not on call. We will feel free to give us a feedback, and we will directly implement that. And we will also mention the valuable feedback in our upcoming lectures as well. Thank you for watching all this time, and I hope your preparation is going well. In the next video, before we start the DPSP and all, we will be bringing some MCQs and PYCQs, so that all the part third, starting from the very first lecture, will get revised. And before you move further, by the time MCQs and PYCQs would be of 30-minute duration, I request you to go to the very first lecture note that you have been preparing along with me and revise all that thing. That will be helpful for doing the PYQs and MCQs. And before you watch the videos on the PYQs and MCQs, you go on the portal and attempt for yourself, see how many you are getting it right, how many you are getting it wrong. You can take a snap and share it on the WhatsApp community as well. Thank you. Let us meet in the next video lecture.